think we should be ready to start, or should we wait? Okay, I think we can start. Good afternoon again to everyone who attended. I hope everyone is well this Friday afternoon. Welcome to the IAIS Dialogue, a dialogue in AI Law and Ethics Forum. I'm the director for Indonesia AI Society, AIS Directorate of Regulation and Ethics. I thank you for your attendance and participation in this event. As an opening, I would like to imagine for us a world where AI can help us diagnose disease, improve education, enhance security, and create new opportunities. Imagine as well a world where AI can harm us, discriminate us, manipulate us, and threaten our values. What should we do to minimize the negative impact while getting the benefits of AI for our society or humanity? Those are the questions for our meeting today, our discussion today, with our distinguished speaker, Mr. Hiroyuki Sanbe, who will share his insight and experiences on AI regulation and ethics from different perspectives and contexts. We hope that the discussion will help relevant stakeholders in perceiving AI from ethics and regulation perspective in various countries. Thus, this discussion will enable us to start developing necessary steps in advancing proper AI governance. This initiative will involve all of us, policymakers, business owners, academics, researchers, as well as AI users. We are all going to take part in fostering this initiative. In regards to Indonesia, in order to bridge the gap between current state and ideal state of our law and regulation in AI, we need to take several steps. First of all, we need to conduct a comprehensive assessment of existing legal framework, engage in a multi-stake dialogue, align our national strategy with international standards and best practices, as well as monitor and evaluate the impact of our policies and regulation directly in our society. None of these steps are going to be easy nor straightforward, but they are necessary and urgent. And this is why we are here today, to learn from each other, to exchange ideas and find solutions, as well as to build partnerships for better future AI with everyone. Matthias?
Yes, hello, good afternoon. Thank you very much for attending this event. Before we start this fruitful discussion, I would like to emphasize some kind of rules. Number one, this discussion will be conducted in English. So if you have a question in Bahasa Indonesia, you can chat us through the chat room, and we will translate to English, and we will ask to the speaker. And second, this is an informal discussion, so feel free to ask everything related to the topic. This is a very casual discussion. We hope that this event will ignite several of initiatives from all stakeholders in order to regulate, to view AI as a part of regulation and policies that we would like to collaborate in the near future. So Indonesia is at a critical juncture in its AI journey. As the largest Southeast Asian nation by population, geography, and gross domestic product, Indonesia has a booming e-commerce market, a rapidly growing internet user base, and a flourishing AI industry. Indonesia has also published its national AI strategy from 2020 to 2045, which aims to leverage AI for economic growth, social welfare, and national resilience. However, Indonesia also faces many challenges and complexities in designing and implementing effective and fair or trustworthy AI regulations. Indonesia lags behind its peers in internet infrastructure, AI talent, and cybersecurity. Indonesia also needs to balance its strategic partnership with other countries, for example, the United States of America and China, who are investing heavily in Indonesia's commercial AI and data sector. Moreover, Indonesia needs to find its own voice and vision for AI governance that reflects its unique environment and culture. The current state of Indonesia's law and regulations in AI is still evolving and developing. There are some existing laws that cover aspects of data protection, consumer protection, electronic transactions, cybercrime, and intellectual property rights that are relevant to AI applications. However, there are also gaps and inconsistencies that needs to be addressed. Therefore, we would like to ignite a balanced discussion to enrich us about what and how experts see, think, and do in resolving these outstanding issues. So in this session, we will be having Mr. Hiroyuki Sanbe. He is a partner of Atsumi Sakai, a large law firm based in Tokyo, Japan. He is also admitted in Japan and New York, United States of America. He provides various legal supports regarding innovative matters in relation to, among others, artificial intelligence, privacy, data protection, blockchain, fintech, and healthcare, as well as merger and acquisitions and capital markets. He concurrently acts as a member of expert groups of Japanese ministries and a leading political party in relation to innovations, including the working group of the project team on evolution and implementation of AI of the Liberal Democratic Party of Japan. He is also acting as a guest professor of Osaka University. So without further ado, I would like to welcome Mr. Hiroyuki to this Zoom. Hello, Hiro, how are you?
Fine, thank you. How are you?
Fine, fine. What time is it in Japan right now?
4 p.m. right now. 4
okay.
right now.
Okay, it's not quite far. Okay, so before I start, I would like to bring up some kind of format discussion for this event to all audience. So we will be having around 30 minutes at max for Hiroyuki to present his ideas and thoughts regarding these themes. And there will be a 15 to 20 minutes Q&A sessions. I would like to welcome all audience to ask everything that you are currently facing, maybe, or everything that you are thinking about the AI policy and regulation, especially in our country, in order to give us more inspiration from Japan as one of the leading countries in terms of research, innovation, and hopefully in the near future AI policies in global context. And also, as Japan is currently the chairman of G7, so it will be very beneficial for us to learn more from Hiroyuki Sanbe about what is happening in Japan as the chairman of G7. And moreover, for my personal note, I would like to learn more about some sake of the a progressive step regarding the ethics and responsible AI regulation as a part of the resolution adopted by G7 in Japan around June or May last month. So Hiro, please give us some thoughts and share us anything that you would like to say in this fruitful forum.
Thank you. So good afternoon, everyone. This is Hiroyuki Sanbe, and I'm as Matthias said, I am a partner with Atsumi Sakai, which is a large law firm in Japan. And I'm very pleased to be here, and I hope that there will be good opportunities where you and we can be collaborating with each other. So I'd like to share my slides. Just a moment, please. So I'd like to explain my thoughts on the discussions on the AI regulation. So many countries are facing with difficulties on how to regulate AI, and especially in relation to the generative AI, the regulators are at a loss how to regulate the phenomenon caused by the generative AI. And in this seminar, I'd like to illustrate the trends in EU, United States, and Japan, and then I'd like to briefly move on to. I'd like to briefly illustrate the current discussions at the G7 summit and the after that. So the first regulation is the Draft AI Act in EU. And the EU has proposed the regulation in April 2021. And this was welcomed by many related persons with the surprise, because the EU has proposed a horizontal regulation which can be applied to many countries and many companies. And one of the biggest characteristics of the EU AI Act is a risk-based approach, which means that the regulation is changing depending on the related risks. And more concretely, the risks are divided into four risks. And the first risk is an unacceptable risk. And AI with unacceptable risk cannot be sold in EU and cannot be accepted in EU. And AI with unacceptable risks can be divided into several categories, like for example, the real-time remote biometric identification for the purpose of law enforcement, or the social scoring by governments for the purpose of discriminating persons, or categorize as exploitation of age or physical or mental illness or something, or disability or something like that. And if AI will do this kind of thing, that AI will be categorized as AI with unacceptable risk, and this kind of AI will not be this kind of AI cannot be sold in EU. This is the first category. And the second category is AI with high risk AI systems. And this includes two categories. One is the AI which is used for the purpose of safety or safety components. And for example, if we use AI for the safety components of cars or vessels or elevators or something like that, this AI will be high-risk AI. And another category is the AI which can be which may discriminate the human beings. For example, if AI is used for the purpose of the selecting persons admission of universities or recruit purpose, this AI may discriminate the human beings, and thus that AI can be categorized as a high-risk AI. And this AI may abide by certain requirements, like the risk management system, or is a technical documentation requirements or something like that. And the providers for the high-risk AI must, among other things, go through the prior prior conformity assessment. And the prior conformity assessment means that the providers of high-risk AI must show that their AI is fitting the requirements for high-risk AI. So this means that high-risk AI must follow the hard law. And compared to the unacceptable risk or high risk, limited risk or minimal risk AI can have no or very limited hard law requirements. And the limited risk AI is, for example, the chatbots or deepfake or something like that. And the providers for limited risk AI must say that we are using AI or something like that. And other than that, there is no legal requirement. And with respect to the minimal risk AI, there is no legal requirement. And with respect to limited or minimal risk AI, only it is recommended to have the some kind of self-regulatory scheme or something like that. But in any case, it is not necessary for them to abide by the hard law in most cases. And this is a proposal by the European Commission. And after that, there are the versions of the Council of European Union and also European Parliament. And among others, the Council covers general purpose AI, and the Parliament provides obligations related to foundation models, of course, including the generative AI. And now the Council, Parliament, and the Commission is holding the trilogue in order to resolve the differences among versions. And I assume that hopefully within 2023 and at the latest until the early 2024, it is very likely that the AI Act will go into effect. And after that, there will be the grace period, maybe 2-year grace period until the time when the AI Act will be implemented against the companies. This is proposals from the EU. And compared to this, the US federal government is trying to apply the existing laws as much as possible. For example, Federal Trade Commission, FTC, is trying to apply FTC Act, Equal Credit Opportunity Act, and Fair Credit Reporting Act. And likewise, other governmental agencies like EEOC, SEC, and CFPB are trying to apply the existing laws and regulations. At the same time, recently, the federal government is trying to propose some new laws and regulations. For example, the American Data Privacy and Protection Act, ADPPA, are proposed by not only by the Democrats, but also by the Republicans. And in a sense, it is likely that ADPPA will pass the Congress. Of course, there have been the opposition, opposition by some stakeholders like the state of California. And in a sense, it may take some time that the ADPPA will pass the Congress. But in any case, it is likely that ADPPA will pass the Congress. And compared to this, I'm not sure whether Algorithmic Accountability Act will pass the Congress. But in any case, there have been the proposal for the Algorithmic Accountability Act. And also, the Senate Majority Leader, Mr. Schumer's framework has been proposed. And in a sense, and also I understand that there have been some other proposals from the senators. And in a sense, nowadays, the the trends of the proposals for the new laws and regulations are emerging compared to before. And especially, as you may be aware, in mid-May, there have been the hearing of the three knowledgeable persons, Sam Altman, Mr. Sam Altman, Ms. Christina Montgomery, and sorry, I don't remember his name, but the professor of New York University. They surprisingly, all of them said that the new laws and regulations are necessary. So it was surprising not only to me, but also to many persons, including senators. And one of the senators said that it is the first time for him to experience this kind of hearing where the knowledgeable persons, all of the knowledgeable persons said that the laws and the regulations are necessary. And in a sense, it is very likely that the US will have the laws and the regulations which are applicable to not only to generative AI, but also to the AI as a whole. And compared to federal government, the state governments have already enacted some kind of laws, and also some of the states are trying to have the regulations. And I understand that more than 20 states are trying to have the regulations, or have already had the regulations. In relation to privacy or biometric information. And also, notably, that, for example, New York City and New York State have the regime protecting employees from the AI used for the purpose of selecting employees. And also, of course, the consumer protection regime can be applied. And also, some states have the regulation of chatbots or deepfakes. And in a sense, it is also necessary for us to pay attention not only to the federal regulation, but also to the state regulation in relation to the United States. And shall we move on to Japan? And until very recently, Japan found like soft law, and especially the two governmental agencies clearly stated that they would like to have the non-binding legally binding frameworks. But some of the members of the Diet, by the way, Diet is a Japanese version of Congress, and some Diet members changed their mind, and they instructed the governmental agencies to consider what kind of laws and regulations will be necessary. And as a result, on April 13th, 2023, we had the AI white paper. And that AI white paper was published by the Liberal Democratic Party of Japan, which is a ruling political party in Japan. And by the way, I was a member of the working group of the project team, which was set by the Liberal Democratic Party, and I have contributed a lot when they drafted the AI white paper. And this AI white paper will be the Japanese AI national strategies, especially in relation to where Japan as a nation will invest in order to foster AI and AI smart cities, and also AI laws and regulations. So I'd like to illustrate these points. First of all, there have been the discussions that the Japan as a nation should invest a lot for the fundamental research and development of unique foundation model in order to compete with the United States or Europe. But as a result of the discussions among the knowledgeable experts, we decided to adopt the option 2, where we equally invest in the some some routes, like including, of course, the fundamental research and development of unique foundation model, but also the applied R&D of foundation model, which was created by, for example, United States companies or UK companies. And also, many fields where Japan has technological advantages in R&D of AI. As you may be aware, Japan has developed AI, excluding the generative AI, for the purpose of many fields, like the AI which can be used for the financial transactions, or AI which can be used for the agriculture, or AI which can be used for the monitoring purpose by utilizing camera and the like. And in a sense, it is not so good for us to concentrate on fundamental research and development of the unique foundation model in order for the purpose of competing with the US companies. And it is also good to diversify our investments in many routes, because if we compete with the United States or especially China, it is likely that Japan will be defeated, because United States or China has invested a lot. Of course, China has very huge AI towns in many cities, and also the United States have invested maybe 60 times compared to Japan, and in a sense, it is not feasible to compete with the United States or China, and in a sense, Japan decided to diversify its investment in AI. And so, as I said, not only creating the original foundation model, but also the applied research and development of ChatGPT or Azure OpenAI service or any other generative model will be the route for Japan. For example, a major bank would like to use it for improving services for customers of the bank. By the way, my clients, which are doing the high-frequency trading of securities or derivatives, are also considering utilizing the ChatGPT or any other generative AI. And also, the major commercial firm of Japan intends to use the generative AI for creating new medicines. And also, stakeholders of agriculture would like to use the generative AI to improve the crop yield, amount, and quality. And as I said, Japan has already a technological advantage. In a sense, there have been the AI other than the generative AI, which can be used for image, finance, medical, or nursing care, power generation, and the like. And in a sense, we are thinking combining these the generative AI which are created in foreign countries, and also the fields where the Japan has technological advantages. And in this field, we Japanese companies or Japanese governments would like to collaborate with foreign countries, of course, with Indonesia. And in a sense, any idea for combining the idea, combining technologies will be welcomed by the Japanese companies or governments. And in a sense, if you have any idea, please let me know. And I'm very happy to connect with you and Japanese relevant counterparties. And also, the AI white paper mentions the AI smart cities, because in order to maximize the Japanese advantage, the Japanese government would like to foster the AI smart cities. As you may be aware, the Japanese rural or municipal governments are facing with financial difficulties and declining populations. And in order to address this kind of issues, they would like to utilize the evolving AI. And if we succeeded in utilizing AI for all aspects of civic life, and by collaborating with each other, it may be possible for us to improve the quality of life of citizens and also the efficiency of activities in local governments. And importantly, we are also thinking on AI laws and regulations, and we are thinking about having the regulations in at least three areas, like the serious human rights violations, or national security, or unjustified intervention in the democratic processes. And I assume that this kind of issues can be should be addressed not only by Japan but also by many countries, of course, including your country. And in this context, we also like to collaborate with your country. And by the way, so we understand that there are risks. At least three risks that violate human rights, health, and safety, including crime or risks of exploiting vulnerabilities, such as children or disabled persons, and also risks of AI being used for citizen surveillance, like the authoritarian states. And also there are second types of risks, national security risk, like the risks of military use of AI or cyber attacks, or importantly, risks of disinformation. And also the third types of risks of undue intervention in the democratic process, like the risks of foreign forces using the AI technology to interfere with elections, like the elections of the president of the United States in 2016. And by the way, so these kind of risks can be shared among the many countries. But with a peculiar, in relation to Japan, we are also facing the other types of risks, like the existing laws and regulations. And Japan's existing laws and regulations are not expecting the emergence of AI. And in that sense, it is necessary for us to adjust or amend them so that AI innovation will be fostered without undue restrictions. And as a lawyer, I have experiences, many cases almost 100 cases where the existing laws and regulations are a hurdle for the innovations. On the other hand, it is also necessary to apply existing laws and regulations. So in order to, for example, protect the ordinary persons, or in order to protect some interests which should be protected. And in a sense, it is also necessary for us to amend laws and regulations, and also to create the laws and regulations which are at a deficit. Finally, I'd like to briefly mention the G7 summit Hiroshima, Japan, which were held in May. By the way, it is my great pleasure to welcome His Excellency Mr. Joko Widodo, and also because it is strengthened the relationships between Indonesia and Japan, and it has a very good opportunity that Prime Minister Mr. Fumio Kishida of Japan has met the President Joko Widodo. And importantly, we have decided at G7 to further advancing the multi-stakeholder approaches to development of standards for AI. And there is a very important phrase, respectful of legally binding frameworks. And in a sense, it is very likely that G7 will have some kind of proposal for the purpose of having the legally binding frameworks. And also, we are discussing in the name of the Hiroshima AI process in order to have the good governance or safeguard of intellectual property rights, including copyrights. And in order to promote the transparency, and in order to prevent the information manipulation or disinformation, and in order to have the good framework for the responsible utilization of the technologies. And in a sense, this can be a shared concept not only by the G7 countries, but also by the many democratic countries like yours. And in a sense, I look forward to collaborating with you in the near future in order to have the good ecosystem or atmosphere for fostering the AI innovation. Thank you very much for hearing my presentation.
Thank you, Hiro, for your, I can say, quite comprehensive elaboration and presentation. So again, before we start the Q&A session, I would like to emphasize to all the audience, if you would like to raise the question directly, you can raise your hand by clicking the raise hand tool in the Zoom menu. However, if you would like to raise it by chat, you can chat to the chat column, and we will read it for you to the speaker. And if you have some kind of difficulty in asking the question in English, you can type the bahasa question, and we will translate it to you for the expert. So before we start the Q&A, I would like to summarize some of the presentation from Hiro, especially regarding about the similarities between Indonesia and Japan. In my personal experience, I'm very agree with you. At some point, this type of form of regulation that we are having right now is quite similar with what is happening in Japan, especially about the balancing between innovation and especially about the legal certainty among other AI stakeholders and especially the AI users. And as we have enacted the AI national strategy in 2020. We also emphasize that the AI, especially in the forms of ethics and policy, should be the main pillar and foundation in creating an inclusive AI ecosystem, and yet achieve the legal certainty and social justice for all the stakeholders. So to be honest, a hero, before we have this meeting, I read the white paper, and I would like to ask, what is the standpoint of from the party, especially as a political force, to drive this as one of the priority that Japan would like to enact. Especially this is quite, to be honest, is quite uncommon because in our country, this, for example, the IAIS strategy came from the initiative from the government institution. However, this kind of initiative from in Japan area comes from the political party. What is the consideration about that, Hiro?
Yeah, thank you very much. And yeah, even in Japan, this kind of trend is a little bit, abnormal because usually the governmental agencies are creating some kind of draft policy, and the ruling political parties approve that policy, and the bill will be created, and the bill will pass the Japanese Congress. This is a normal style, and in a sense, it is a little bit abnormal or surprising to me that the Japanese Liberal Democratic Party has strongly instructed the governmental agencies to change their mind.
Okay, okay. So it's quite unusual from your side also, I think. Okay. Before we send it to the audience, just one last question from me. What is the position of Japan, especially in the white paper regarding ethics of AI? Because as far as I concerned from the Japan white paper that just published by the party, it hasn't covered about the ethics of AI. Is that something that other consideration that from your side, especially from the expert of the party, would like to do in the future about the ethics, or is there kind of some strategy that the Japan would like to do?
Thank you very much. And for the avoidance of doubt, Japan has heavily paid attention to ethics, and because the governmental agencies thought that because we paid attention to ethics, it is not necessary for us to have the hard law or legally binding frameworks. And in that sense, Japan is a country which has mostly paid attention to ethics, and this is because when we collaborated with the EU countries or EU companies in, for example, 2016 or 2017, they always said that if Japan does not respect ethics, we may not collaborate with you because ethical standards are protected by laws and regulations in Europe, and if Japan violates ethics, it is likely that not only the violation of ethics, but also the violation of the European laws and regulations. And since then, Japan has paid attention to European style of ethics. And nowadays, Japan has changed their mind because not only ethical standards, but also some kind of threats are approaching, like the disinformation or national security risks or something like that. And in a sense, we understand the necessity to codify some kind of hard law. And the issue is not whether or not we should have hard law, but the real issue is whether what kind of laws we should have right now.
Okay. All right. Okay. Thank you, Hiro, for your explanation. It's quite clear for me. We have one question from Professor Hamam Riza. Hello, Professor Hamam. I would like to welcome him to this forum also. He sent a question in the chat box. He asked it about is there any experience from your side or from Japan about how the nation ideology or philosophy could be included in the body of the regulation about AI, especially from the white label has said in the document, Hiro?
Thank you very much. And it is a very good question, because we had a similar discussions when we discussed with Diet members of the Liberal Democratic Party. One Diet member said that we would like to insist, if the EU would like to insist some kind of value, that we like to insist the value of the Eastern or Eastern and Southeastern Asian countries, the value of the Asian countries. And but I explained that EU's value is not the, for example, is not the religion or some kind of tradition or something like that, but the EU's value is human rights or rule of law or democracy or something like that. And in a sense, if we consider having the laws and the regulations, we should have the such a notions which can be shared among many democratic countries. Otherwise, it is not possible to have the similar laws and the regulations. And if we have the different types of laws and regulations with the background of the original value of the Asian countries or something like that, it is likely that we, if we try to export AI products or AI services to Western countries, there will be the hurdle, because the laws and the regulations are different. And given this kind of scenario, we should have the similar laws and regulations, which are similar to the ones in the Europe or the United States, in order to foster the transactions, for example, the export and import and investments and M&As. And in order to have that kind of transactions, we should have similar laws and regulations. And of course, within Indonesia or within Japan, it is possible for us to have the Asian values or Asian ethics. But it is likely that insisting this kind of Asian value to the Western countries will give rise to the some kind of hurdle for the export or import of the AI products. And in a sense, the bottom line is that we will have I understand that we should have the similar laws and regulations with the US or the European countries.
All right, thank you, Hiro. We have another question in chat box from Mr. Eko Widodo. I would like to welcome him also in this forum. I will read the question. He asked, in Indonesia, the application of regulations related to technology usually does not last long. As an example of the application of the law on information technology in Indonesia, which currently has new demands for revision. So it is feared that the law related to AI will also be the same. There will be a change in the rules in a short time. This creates high uncertainty. Meanwhile, technological progress cannot be stopped. What is your opinion? This is a good question, actually, Hiro.
Yeah, this is a very good question. I think so too. And but at the same time, without the legally binding frameworks, it is not possible for us to prevent the bad actors or threats of the authoritarian governments. And in a sense, some kind of laws and regulations are definitely necessary. And in a sense, the issue is what kind of risks should be addressed by the laws and regulations, and what kind of risks and risks should be addressed by the guidelines or market standards or any other soft law. And in essence, we should consider the categorizing the two types of risks. The risks should be which should be addressed by the legally binding frameworks, and the risks which should be addressed by soft law.
Okay, thank you. I hope it answered your question, Mr. Eko. So we have another two questions in chat box. I would like to welcome Pukovisa Prawiroharjo. I would like to read the question. Thank you for the presentation, Mr. Sanbe. I want to ask, Japan has been a forefront in their health system. What changes has to bring to the healthcare system? Is there any plan or ongoing regulation for AI use in healthcare?
Very good question, and I like to have the answer to this question. Right now, we have had the very limited area of the laws and the regulations which have been amended for the purpose of AI. For example, we have amended the Medical Device Act in order to expedite the process of the certification or authorization of the medical device utilizing the AI. And also we have the guidance of the doctors utilizing the AI. But other than that, there are very limited areas where the medical care laws and regulations have been amended. And in the sense, every day I face the difficulties in relation to the current laws and regulations. And I like to have answers to this question. And in a sense, I like to cooperate with the person who asked this question. And in any case, this is a very good question. And we should always consider this kind of issue related to healthcare or, for example, financial transactions or financial regulatory issues or something like that.
Okay. Okay. So Pukovisa, if you would like to ask Hiroyuki in person, you can add his LinkedIn after this. So we have another question. Oh, it's quite a lot. One, I would like to welcome Mas Agustinus Lanang. Hello, Mas Lanang. He asked, I would like to ask in chat, in your opinion, how AI applied in Japan influences a lot of Japanese people, especially who hold strongly in religious life and culture. Should AI laws be implemented based on a country's context, or should AI law be unified around the world? Because AI is global thing that we can learn anywhere.
Thank you very much. And as I said, my previous answer is applicable here as well. And in order to expedite the trade, export or import or M&As or investments, the laws and the regulations should be similar among most of the countries. But on the other hand, each country has a religions or own culture or something like that, and in that sense, it is also necessary that each country should have the unique laws and the regulations or ethical standards or market standards or something like that. And again, this kind of things should be divided. We think we should think differently for these two issues.
Okay, thank you. We have other question from Pak Edmond Makarim. Hello, Pak. I would like to welcome you in this forum. He asked it, can you mention what kind of legal provisions from the Japanese existing regulations that give undue restriction to the AI innovation?
Sorry.
Hello, Pak.
Yeah, hello. Sorry, signal in Bangka, it's not so good.
It's okay. It's okay, Pak Edmond. Thank you very much for asking the question. Yeah, so I would like to reread again, Hiro, for your reference about the question. So Paitmon asked it about, can you mention what kind of legal provisions from the Japanese existing regulations that give undue restriction to the AI innovation?
Thank you very much. There are many, many examples. And for example, with respect to the nursing care with the camera, previous Japanese guidelines said that using camera can be is allowed in very exceptional cases, because the using camera can be the binding effect or some kind of the bad effects on the patients. And in a sense, it is if the manufacturers of AI products would like to utilize AI camera for the purpose of protecting the patients in nursing care, they always face this kind of the previous guidelines. And we needed to discuss with the relevant ministry, and the ministry has not even now has not amended the guidelines, but I have persuaded the ministry in order to achieve the results that guidelines will not applicable to the case of our clients. And we successfully persuaded the ministry. But in any case, the other countries, which are not clients of our firm, are facing always this kind of issues. And also, as you may be aware, with respect to the autonomous driving, many countries have amended the traffic rules, and Japan also amended the Road Traffic Act so that the so-called level 4 autonomous driving can be done in Japan. But even so, there are many laws and regulations which should be amended. For example, the civil and criminal liability regime should be amended so that who will be liable will be cleared. Will be clearer. And also, even so, if some company faces a high amount of liability, then the innovation will, decreasing. So some kind of insurance scheme will be necessary. And Japan has no specific laws and regulations for the AI insurance scheme for AI. And in a sense, we need to consider having the AI insurance scheme. And also, with respect to the sensors or something like that, there are no safety standards for sensors. So nowadays, Japan has a scheme for approval of the level 4 autonomous driving, but this will take very long time to get approval. So there should be some kind of safety standards which can be applied to many cases in order to expedite the process for implementing the level 4 autonomous driving. This is also one example. And there are many examples in relation to, for example, financial regulatory law or labor law or agricultural law or something like that. So it is not possible for me to raise all of the examples. But the bottom line is that if the existing laws prohibits something in relation to AI, the utilization of AI. This kind of laws should be amended. And second, if the laws and the regulations requires the human being intervention of human being, this kind of laws and regulations must be amended. Also, even these two types of laws are amended. This is not sufficient because in order that the AI will be prevalent, then some kind of environment should be prepared by the laws and regulations. For example, as I said, the liability regime should be prepared, or insurance scheme should be prepared, or something like that. So if the bottom line is that the environment must be prepared by the laws and regulations. Otherwise, the AI innovation will not be prevalent in any country.
Okay, thank you, Hiro, for the answer. So we don't have any question in the chat box. Is there anyone who'd like to raise the question directly? You can raise your hand. Okay, in the meantime, I would like to ask another question to you, Hiro. I'm sorry about that. So I would like to circle back to the white paper, yeah, Hiro. So one of the key takeaways about the white paper that I highlighted is about the agile regulatory adaptation in AI, especially the white paper elaborated about the importance of being agile, adaptive in terms of regulatory approach in Japan. Just from your experience as a legal practitioner and also the expert in this white paper, what kind of the current regulatory form that are currently applied in Japan, and what kind of adaptive and agile regulation that Japan would like to have in the future regarding this technology?
Yeah, thank you very much. And one ministry said that agile or adaptive governance will be fostering the AI innovation. And it is partly true because without doing if we have the hard regulation or undue regulation, it is likely that the AI innovation will disappear. But that ministry is now changing their mind because they like to have some kind of at least guidelines and also maybe the hard law for certain types, at least certain types of risks. Because without that kind of hard law or guidelines, it is likely that some kind of risks or bad actors cannot be prevented. And in that sense, the Japanese governmental agencies are trying to strike the balance between the preventing the serious risks and fostering the innovations. And in any case, the Japanese government is now not thinking that the hard law will be the hard law for the AI innovation. Rather, they are now thinking that the AI hard law is necessary for fostering the innovation.
Okay, thank you. So you mentioned about the guideline. From Indonesia's standpoint, especially from my personal opinion, is that if there's any legal practitioner in Indonesia or a government official that would like to correct my opinion, please do so. Guideline is quite hard in Indonesia because type of regulation that we currently have. And on the other side, it is quite understandable if several countries implement the guideline as part of their legal enforcement or legal regulatory approach that they would like to impose. One question from my part, what kind of guideline that you would like to have? Is there any kind of the same power or legal enforcement with the hard law? Or is it just like a very soft law which mandates several of self-regulatory compliance from the AI players or stakeholders?
I'm sorry, so I couldn't understand the latter half of what you said. Could you tell me again?
Yeah. So the question is, as you said that there will be guidelines and hard law as a part of Japan's visionary regulatory approach, as in achieving the say the agile regulatory forms in Japan. I would like to say in terms of guideline type of forms of regulation, Hiro, what is the difference between the guideline and the hard law in terms of legal enforcement, and also the applicability of applying the compliance and encouraging the AI stakeholders in complying with lots of say the recommendations or suggestions or terms and provisions stipulated in the guidelines.
Yeah, and as I said, Japan had respected soft law until very recently, and in a sense, there are very limited AI hard law which can be specifically applied to AI. And in a sense, in a short term, it is necessary for us to think about the AI guidelines in order to govern, in order that the AI companies can rely on certain criteria. And at the same time, with respect to the high or serious risks, the Japanese government is collaborating with other G7 countries, and they will have some kind of attitude in relation to hard law, and they will clarify that their attitude until the end of by the end of this year. And at the time, the Japan will think about how to implement the results of the discussions of G7 into the Japanese laws and regulations. And at the time, Japan will think about amending or creating new laws and regulations.
Okay, all right, thank you. Okay, I would like to welcome again everyone who would like to ask some question in this session. Please raise your hand or type the question in the chat box so I can ask it directly. No,
one person is raising hand.
Okay, let me see. I didn't see anyone raising hand.
So I'm sorry, Ms. So. Oh, sorry. I misunderstood this. This is not a raising hand. I'm sorry.
Okay. It's okay. It's okay. I think Payanka, you have some question because you're unmuted.
Yeah. Yes. Actually, I have a question. Someone is actually is coming from someone else. With the rise of the generative AI, and it's a lot of the creative industry people is very concerned. Japan has a pretty big creative industry export, right, to the world. They, I think the last time I checked, it was about almost 5 trillion yen, or about 35 billion US. Is there anything that a government or regulator in Japan is doing to ensure that the threat, again, it could be a threat because the art and the design services is going to be is changing very rapidly with the rise of the generative AI foundational model. And like I saw in the Hiroshima AI process, right? There's a talk about IP, but most of the time when talk about AI IP protection, it goes for the model itself, not what's being generated or the community or the people being impacted. Yeah. So that's the question that that I have about the generative AI and Japanese Japan art creative industry.
So I'm sorry. So frankly speaking, I couldn't understand your question. So so you would you like to like me to answer the how Japan perceives the threats of the generative AI, or how Japan will collaborate with or utilizing the generative AI?
More in the more on the threat side, because
okay.
a lot of the art is being done by humans as of now, right? Like animations, books, and all that stuff. But with generative AI, it's changing the industrial landscape. And Japan has one of the big cultural and design services in the world. So how is it going to? How is the risk being mitigated with this issue?
Yeah. Yeah, this is a very good question, and as you may be aware, so there are some problematic cases where, for example, the trade secrets are leaked when some company are using the chat GPT, and also there are some risks of violating the copyrights or something like that. So according to the newspaper, most of the Japanese people like having the laws and regulations on the generative AI, and this is the reason why. This is because the Japanese people would like to avoid the risks of invading someone's rights. And in a sense, they would like to have the clear guardrail or clear line of the violating or non-violating the legal rights of someone. And in a sense, as Henke said, there are many threats which are paid attention to by the Japanese people. And right now, the Japanese government and also the government agencies are considering what kind of risks should be prioritized. For example, most of the Japanese people are considering, among others, the disinformation risk and also the violation of copyright. And in that sense, the Japanese government is collaborating with other G7 countries in this respect. And also the Japanese one agency in charge of the copyright clarified how the current Copyright Act is applies to the generative AI or the art generated by the generative AI. And in a sense, Japan is in the middle of addressing these threats or risks of generative AI. And in this process, it is likely that we, Japan, will collaborate with other countries, of course, with including with Indonesia. And I hope that we can collaborate with each other. And also, the Japanese government would like to grasp the trends in foreign countries. And in a sense, if you have any specific risks which should be addressed, if you notice any risks which should be addressed by many countries, please let me know. And I would like to tell your voice to the Liberal Democratic Party or Japanese government itself on behalf of you.
All right, thank you. I think that's a great answer. We actually have a agency dedicated on this issue. That's really great, actually. Yeah, thank you, Hiro.
Okay, thank you, Paimka, for the question. Is there any question on the floor that any of you would like to ask? If not, I would like to raise my very last question. Okay. So, Hiro, this will be my last question in this for you.
Yep.
To you. It's quite basic actually. What is the position and perspective of AI in industry and also users from your standpoint as a lawyer? I believe you handle some kind of clients who might utilize AI as their product or as their working flows that you would like to serve the best in terms of compliance and legal advisory. But more than that, what is the acceptance from the users, especially from your side, about AI in Japan? Because it is quite something important for us as a country. Based on the latest research that I just read yesterday, the acceptance rate about AI in Indonesia is quite worrying. It is around 46% people would like to use AI in the near future. However, as you said before, AI could be used for a greater impact and for positive benefit, especially for, say, digital transformation and to improve humans' quality. However, several of the negative concerns around AI has been evolving, especially in our country. So, from your standpoint, what is the perception of AI? And if I may know if the perception is good, what is the secret behind it? Because we would like to learn more about.
The AI can have the greater effects positively for the Japanese or foreign people's lives, and in that sense, it is definitely necessary for Japan to foster the AI innovation. And first of all, I like to be supportive of companies dealing with AI, whether Japanese or foreign. And in that sense, if there is any opportunity where I can supportive of you, this will be very happy to me. And also, Japan, although Japan could not create the generative AI by itself, Japan has a very good areas where we can collaborate with EU and any other countries. And in a sense, it is I look forward to any opportunity where we can seek the business opportunities utilizing the AI, whether generative AI or otherwise. And in this context, I'm not sure whether or not the Japanese government will create a good opportunity, but I always talk to the Japanese government or Liberal Democratic Party that we should accept the Asian genius in relation to AI or related industries. And Japan has not succeeded in accepting the Asian genius from other Asian countries. And now I always think that we should accept the genius in Asian countries, of course in Indonesia, and in order to foster the AI innovation, which can be shared among the Asian countries. And I hope that this kind of the human collaboration will happen in Japan and of course in Indonesia and also in any Asian country. And the bottom line is that we should seek the collaboration with each other in any aspect in relation to AI. And I look forward to that kind of opportunities.
Right. Thank you, Hiro, for the very good answer from your side. So since we come to the end of this forum, I would like to summarize what we have learned for almost 1 hour and a half. So the first point is Japan is a country that is still growing themselves in terms of AI regulation. They have several of initiatives, especially about the white paper of AI that they just launched at the end of last year, and they will continue improving and growing the regulatory approach by making it more agile, adaptive, and catch up with the latest innovation. And most importantly, there are some kind of opportunities that in both countries, Japan and Indonesia, that could be justified in order to create more and more interactive and collaborative international policy cooperation, and also international build bilateral strategic collaboration between both government to government, community to community, and expert to expert. So before I end this session, Hiro, you have some closing remarks about what we just learned today?
Yeah, thank you very much for taking time to hear my presentation. And I really enjoyed talking with you and also answering your questions. I really look forward to collaborating with you in the future. Thank you very much.
Okay, so just for information to all audience, the slide that Hiro just presented will be sent to you by email from our secretariat, and it should be sent hopefully within this week. So we hope that slide will help all of you within your workplace and also within your areas group of work in implementing more and more and better AI governance, and also hopefully as a country we can create more and more AI regulatory approach and policy making process to be more inclusive and balanced between innovation and legal certainty. So on behalf of the committee of IAIS, I would like to thank you to all the audience and speaker. Hiro, thank you very much for joining and giving a very insightful knowledge for us. And this is not the end. There will be a series of this kind of discussion until the end of this year with another speakers. So we will update you about the development of the other events, and see you at the next event. Thank you very much. Assalamualaikum warahmatullahi wabarakatuh. Good afternoon.
Yeah, thank you very much. Have a good weekend.
Yeah.
Thank you.
So
Thank
much.
you.
Thank you, Hiro.
Thank you.